Alrighty, hi, my name is Sheila. Welcome to my channel. In this video, I'm going to talk about Rocket Lawyers LLC operating agreements, if I can grab that. And I have on my handy dandy reading glasses so that I can actually read what it is I'm going to be talking about. So this is actually a single member LLC agreement that you can use on Rocket Lawyer. I'm actually going to be going over it with you so that, if you have any questions about it or you've been thinking about it, you'll say, hey, Sheila kind of went over this and here were some things she said about it. All right, so there are lots of resources out there for you to use. This particular document, like I said, I'm going to be going over the single LLC operating agreement. This is about 15 pages. I'm not going to go over every single provision on these 15 pages. I'm just going to talk about a few of them, just give you some highlights, things to think about, what matters, what doesn't matter. I don't know. We're going to go through it. All right, so stick around and hey, maybe get your computer, pen, piece of paper, take some notes. And I'm not going to read all of this to you either. Okay, so the very first thing it starts with is formation. And it says this is a limited liability company operating agreement for a manager managed single member LLC. Okay, so you can have two different kinds of LLCs. One would be managed by a member. A member is typically someone who owns the LLC, okay? It's just a different name for it, but it's just considered to be an owner. So you can have member managed, meaning the owner's managing the LLC, or you can hire a manager, meaning it's manager managed, but the owners still own the company, okay? So you can have either one. In this particular one, I just did member managed. A lot of times that's what you're doing, especially if you're a single member LLC. I'm not hiring a manager. I'm running my own professional LLC in the state of North Carolina. Okay, operating agreement controls. This is just saying, hey, this is gonna be under North Carolina law. See, it's got your primary business address. I always tell people to be consistent when you're talking about your primary business address. It's the same address that you're going to put on your IRS documents when you get ready to file taxes. It's the same address that you put down for your principal place of business when you were actually filing the documents to organize the LLC. And now that you've got your operating agreement, guess what? Hey, we've got our principal place of business here. Now, these things can always be amended, okay? But what I don't want to say I don't want to see. I just want to warn people sometimes that if you're going to say that your home is your principal place of business and you're going to put that down in your taxes and you're going to try to deduct that, then you also want to make sure that your organizing documents and your operating agreement say the same thing. Like you don't want to all of a sudden have this different spot, but you're taking off part of your mortgage payment on your IRS return. Yeah, that's not going to work. So keep that consistent. All right, so you've got your primary business address. You've got your registered agent and office for that. Again, this is going to match what is on your organizational documents that you submitted to your state, okay? You're just keeping this consistent, not really that difficult. No state law partnership, and this is just saying no provisions of this agreement shall be deemed or construed to constitute a partnership. I guess I should sort of slow down here. Or joint venture for any purposes other than federal or state tax purposes. So in the end, this is a single member LLC. So I'm not even sure why this provision is even necessary in this document. There's nobody else. It's just one person. So there's really nobody else to partner with. Purposes and powers. I always tell people to be sort of broad with the purpose of your company. You know, sometimes people will say, hey, well, I'm a delivery company. Yeah, I'm in the transportation industry, but right now I just deliver stuff. But I do have plans to expand. Well, then just say you're in the transportation industry. Keep it broad. Then you don't have to amend anything until you like branched out really way to something different than what you're doing. So yeah, so keep that purpose kind of broad. Powers, you have all of the powers that an LLC has been given under your state statute. So for this one, I said North Carolina. So that's what that says. I have all of the powers that North Carolina gives my LLC under the North Carolina Limited Liability Company Act. All right, next is C. You're talking about the company's duration. Now, you can put that this LLC is only going to be around until the end of next year. Or you can just say your LLC is going to be in existence for perpetuity until you decide to dissolve it. And then they have some ways that you can actually terminate this agreement. One would be if the member votes to dissolve the company. Since it's just a single member LLC, that would be fairly easy. No member of the company exists. So for instance, the member dies. It becomes unlawful to continue in business. Hey, what you were doing, that purpose that we just talked about, it's been outlawed. It's now illegal. You can't do it. A judicial decree is entered dissolving the company. Or there's some other reason under federal or state law that is requiring you to dissolve the company. So you've got this sort of termination in there, even though you may still say, hey, we're going to operate this LLC in perpetuity. Next up, we're moving into section 3 about the member, and you're listing who the member is. You're listing what the initial capital contribution is going to be. And usually, for a multi-member LLC, you're going to have this attachment A that's going to list everybody and how much they're contributing and what their percentages of ownership are. In this case, remember, it's a single member LLC, so you're just going to have this one person when you get to the attachment A, and that one person is going to own 100%, right? Okay, so then we have the paragraph that we're all ready to get to is the one that says the limited liability of the member. Okay, that's the whole reason we're using this particular kind of formation, right? So we can limit our personal liability. So you've got that paragraph here. That is the actual limiting language that says you personally are not on the hook for the company's expenses, liabilities, any of those issues that the company may run into. Now, granted, there are some exceptions, but we're not getting into that in this video. All right, then you have a section that talks about the creation and substitution of new members. And so it talks about how you can transfer your membership to somebody else. Well, in this case, it's only one member. So yes, I can sell my company to somebody else. When you have a multi-member LLC, that's when you see this sort of breakdown of voting rights and how you make decisions. So it's more important in one of those. This also talks about partial transfers if you just want to sell part of the company, or if you want to bring a member in who has less of an ownership than you have, especially because, as I tell my members when they come to me, yes, you definitely want to maintain majority ownership in your own LLC. All right, member voting, again, not really a big issue in this. Of course, it has the company's members shall each have voting power equal to its share of the membership interest in the company. So therefore, if you have 100% ownership share, then guess what? You get 100% of the voting rights. That's basically what that says. And that keeps it sort of simple. And if you're in a multi-member one, you can do the language the very same way, so that whatever your ownership is, it ties to your percentage voting rights. Members' duty to file notices. Yes, so you've got to file any other minutes, anything that needs to be filed with your Secretary of State, any IRS documents, all of that you are required to do. And of course, this is just your operating agreement touching on each one of those things. All right, I'm going to skip down to 4 where it talks about accounting and distribution. Fiscal year. It says the company's fiscal year shall end on the last day of December. I tell people, keep it easy, keep it simple. Don't go picking some weird day to have your fiscal year end. And it's like, oh, well, it's September 19th. I had somebody tell me that one time because they said that that was the birthday of a family member. And it's just like, no, we aren't going to do that. Think about it from a practical standpoint, okay? Just about everything you do is on an annual basis. You file your taxes, you get your statements monthly. At the end of the year, you get a 1099 from certain people. Keep it simple so that you can match all of that stuff up. You don't want to have to go back and try to prorate something over the course of a year. And there are some instances where you are required to do things on an annual basis. So don't go messing things up and making it harder for yourself by picking some day out of the blue or something. Next, we're talking about distributions. And it says distributions shall be issued as directed by the company's treasurer or assistant treasurer on a blank basis. So you'll figure out how often you're going to make distributions. So if they're profits, how often you're going to make those for yourself, because remember, you're the only one that's in this single member LLC. So again, fairly simple. And then you've got liabilities also that get allocated out. Tax treatment. So here, the company has not filed with the IRS for treatment as a corporation. Instead, the company will be taxed as a pass-through organization. The member may elect for the company to be treated as a C corporation or an S corporation at any time. So you kept your options open with this particular language in here. Now, if you're familiar with what they're talking about when they talk about a pass-through organization, it just means that the IRS is treating you as a disregarded entity. And because I'm just me and my LLC, that means everything goes on my Schedule C, and I just file that Schedule C with my regular 1040. So my Schedule C will have all of my profits, my losses, everything right up there from the business. I don't have to file a separate whole nother tax return with a whole nother set of numbers and all of that whole different thing over here. I don't have to do that. Everything can run right through the same tax return, which can keep it very simple, which makes a whole lot of sense if it's just one person, okay? We've got a creation of board members that it talks about. You can do that. Next is the powers and operation of the board members. Again, it talks about everything from meetings, notice of meetings, all of that. Not real relevant when it's just a one person, right? So we're going to run through the rest of these. Compensation of managers. Yes, you can pay the managers the salary if you want to. Removal of managers, unless otherwise restricted by law, any manager or the entire board may be removed. Managers as agents, meaning they can step in and bind the company. They can sign contracts that make the company legally responsible to do some act. No power to dissolve the company. So let me read a little bit of this to you. Notwithstanding any other provision in this agreement to the contrary, or any provision of law that otherwise so empowers the board, none of the board shall be authorized or empowered, nor shall they permit the company without the affirmative vote of the member to institute proceedings, to have it bankrupt, insolvent, shut down. Okay? Again, it is the owner who owns this LLC. All right, duties of the board: to keep minutes, records, have meetings. We've got tax returns, not commingling assets, pay its own liabilities, maintain an arm's length with the members. So all of this for this particular document is probably not going to be necessary. So I love that Rocket Lawyer has this sort of comprehensive document available to you, but in most cases, most of the single member LLCs that I work with do not have a separate board, okay? So a lot of this is just not gonna be applicable. So let's go through some more of these, because again, I find quite a few of these to be not so relevant. Like I said before, I've dealt with a lot of single member LLCs, and most of them just really do not function this way. It is usually, one person who's running the show. The decisions get made by that one person. Yes, they do carry out things in the proper manner, meaning they do have the separate bank account, and they do, file things through their Schedule C, because they can do it that way if that's what they're choosing to do and they're not some other entity. But a lot of these other things, I'm just not sure that you need them all, because most people don't really have this board. So then you've got officers, initial officers. It's got a chairman, a secretary, and a treasurer. And this is assuming that your board is going to be having meetings, and that somebody's going to have to keep minutes. Somebody's going to have to run the meeting. Notice, remember I mentioned that earlier. A lot of times you just don't have that. It's in here if you need it, okay? But most of you really are not going to ever use that part of this agreement. They've got each of the roles listed here, the duties. They've got the president, vice presidents, secretary and assistant secretary, treasurer and assistant treasurer, and then officers as agents. Then they go over the fiduciary duties of the board and officers, meaning what kind of duty do these people owe to the company? Let me go through some of those, okay? The managers and officers' fiduciary duties of loyalty and care are to the company and not to other managers and other officers. These include duties of disclosure, good faith, fair dealing to the company. Okay, so it's sort of like, you're supposed to do right by the company as a board member. You're not supposed to try to take advantage of it so that maybe you're able to get some side contracts for your business because you were able to talk to some other companies that are really supposed to be working with the LLC and not you. Like, you aren't supposed to be self-dealing and doing that sort of thing. You are supposed to be looking out for the company. Reliance on reports, they can rely on reports. All right, dissolution, we talked about this a little bit more earlier, and at the end here, it's talking about winding up and taking this time to sort of go through and make sure that any payments that need to be taken care of, any loans that are out there, any obligations of the LLC, they need to be wrapped up and taken care of. So this says, upon the occurrence of any event specified in 11C, which I said earlier would terminate the company, cut that duration short if you're not going to be in existence for perpetuity, shall continue solely for the purpose of winding up its affairs in an orderly manner, liquidating its assets and satisfying the claims of its creditors. So I'm not going to read all of that, but you get the gist of what I'm saying. You're shutting a business down. You're going to do shut down business types of things. Distributions in kind. Any non-cash asset distributed to one or more members shall be valued at its fair market value. And so it's just making things clear. Like, if somebody, it's very obvious when a member makes a contribution that is in cash. You know exactly what the fair market value is, right? It was a check for $5,000. But how is it valued? What do you do when what you're giving is not that, but maybe it's furniture that you're donating, maybe it's equipment that you're giving to the company? So there has to be a way of coming up with that value. And this is just talking about fair market value. You can bring in an independent appraiser, those sorts of things. Termination will occur when all these debts and liabilities, everything has been taken care of. Within a reasonable time after their liquidation, the company treasurer shall furnish the members with a statement. Yeah. All right. So indemnification, there's this indemnification provision in here too that talks about actions that the board members might take. Okay. So as the board members are making decisions, guess what? Hey, I don't want to be personally on the hook, just because I'm a board member at your company. There is an indemnification provision in here that protects them, just like the limited liability protection that exists for the company. So the board members want to be protected also. In the agreement, it'll talk about who's covered under this protection, what they're covered for. So sometimes it's like, you're not going to be covered if you go out and do criminal actions, okay? Like, that's not covered. You broke the law, you're responsible for it, okay? Insurance is required. Notices, if the company's sending out notices, this particular example here says 3 business days. And then you've got like some basic contract provisions that are in like all of the agreements. Things like, hey, if one clause in here is bad, we just take that one out. The rest of the contract is good. You will see that in a lot of agreements under the section called severability. Then we have headings. Attorneys will come up with all of these because usually it means at some point in time somebody tried to say something different. So we will say headings. These headings are for convenience only. Okay, that's it. To help you find the actual language that we're giving value to. We're not giving value to the headings. So don't try to sue under that. Controlling law, North Carolina. Amendment, usually we'll say, hey, this agreement can only be amended by the parties in a writing signed by both parties. This is the entire agreement. Yes, you actually have to put that in there because people will try to come back and say, oh no, remember, but we talked about the day before some other things. So that's part of this too, right? No, it is not a part of this. I tell my clients that all the time when they bring me a contract. The last thing I say is, okay, we've been through this whole contract. Now tell me, was there anything that you talked about that they promised you that is not in this contract? Because this is it. If it's not in here, guess what? It's not in here. So that's the entire agreement. Sometimes it's also referred to as a merger clause. Then you get to the last page and you've got your signature page there. Sometimes people ask me, Sheila, does it need to be notarized? Well, usually notarization is there to confirm identity. So unless you think there's going to be an issue with identity, not necessarily. And then you've got attachment A, as I mentioned earlier, which goes over the contributions of the members, how much each member is giving. And remember, in this case, we're talking about a single member LLC. So typically, whatever the amount that person is giving is going to be 100% of the initial contribution. So that's pretty much it. That's Rocket Lawyers single member LLC operating agreement. Now, what are my thoughts on whether or not you should use that baby? I think it pretty much covers just about everything you need as a single member LLC. I mean, there might be some things that I might phrase a little differently, for instance, that formation piece at the beginning, but is it like the thing that's going to tank your operating agreement? No, because your operating agreement really only exists for you and your accountant. Nobody is going to ask you to turn that over except for people who need it for verification for certain reasons. It's not something that you have to submit to the IRS or to the state, unless there's something else going on. There's not this process where every year you need to update your operating agreement and send it into the Secretary of State. No, that would be your annual report or some other form that's required. This is not it. So in terms of whether or not, I think the Rocket Lawyer LLC operating agreement is something you should use if you're looking for something, I would definitely say yes. Here's the problem. I run into a lot of people who say, oh, I'm all set up. I got everything. I got my LLC. I got my EIN. I'm ready to go. But they don't get that operating agreement. And it's a really good way to just sort of pull it all back together. Like really and truly, you've got a lot of things together when you've got your initial organization documents, your EIN, and your operating agreement, because it's like the formation package is kind of complete. And at that point, it's like, I get my bank account, now I can start working on other contracts and those sorts of things, those sort of next step items. If you cannot find an attorney where you live or an attorney for a price that you can afford, or you need one right now and the attorney you want to talk to is like, look, I can't see you for a month. This is an option for you. I think it's definitely an option that you should consider. So I hope this was helpful to you, just giving you my thoughts on Rocket Lawyers single member LLC operating agreement. I know I sound like I'm rushing through this. I'm really not. So for some reason, I'm just really hyped this afternoon and my energy level is a little high. It's probably going to drop off really fast in about another hour. But go ahead and give the video a thumbs up. Stick around. I'm bringing you more content regarding legal issues. Of course, I have my other channel that talks a little bit more about just like regular lifestyle and living and that sort of stuff. So feel free to check that out too. And don't forget to subscribe. Mwah. Peace.